Hi everyone, welcome to the channel Simple Concepts. I am Rashmita, your educator for the subject Indian Polity. And in this lecture, we are going to talk about the list of most important judgments for UPSC. So what is the importance of learning what are the most important judgments for UPSC? Because they are mostly asked in your prelims exam and then you quote them in your answers in your mains exam, and then some of them are asked also in your interview. So to judge your knowledge that how much you are updated with the judgments and what are your different views on such judgments, the interviewer generally actually asks you कि what are your opinion on this case. तो अगर आपको किसी भी केस के ऊपर अपना ओपिनियन बताना है तो उससे पहले आपको पता होना चाहिए कि उस केस में क्या दिया हुआ है. So in this particular video, I am going to tell you a list of most important judgments for UPSC. Let me tell you first, this is just the list and I'm just going to give you a little brief about all these cases. Okay. बाकी detail में हम आगे के lectures में बात करेंगे. If you want, I'll make a separate video on each and every judgment which is given in this list. So with this, let us begin. So there is this Unacademy UPSC Championship 2.0 All India Free Mock Test Series which is going to held on 30th of August, 6th September, 13th September, 20th September and 27th September. So if you get a good rank in this, you are going to win a chance to meet UPSC CSE 2019 toppers, top Unacademy educators and Unacademy subscription scholarship also. So you can enroll for it right now. It is called Unacademy UPSC Championship 2.0. So as you all know, there are very few days left for your UPSC preparation. So if you want to prepare with Unacademy, you can subscribe for Unacademy right now. I'll tell you what are the benefits of your one-time subscription. Okay, so there are like unlimited benefits. You can learn live from comfort of your home. There is unlimited access to all courses. Like once you subscribe, you get unlimited access to all courses. Also, there will be top educators of India on one platform. You don't have to go here and there to find new educators. Okay, your entire syllabus will be covered. Okay, exhaustive coverage of your syllabus. Next is regular doubt clearing session. So yes, all of the doubts will be cleared by your educators. Okay, there will be separate doubt clearing sessions. Also you will get live test series so that you will get a gist के that fear, you will come across that fear के जो हमें examination hall में होता है. Next is all of your study material will be in PDF format, so you don't have to worry about to go online, or if your internet is not working, everything will be provided in a PDF format. Also answer writing sessions. So you will be given answer writing sessions. So it is to improve your answer writing. So even if in starting you are not good with answers, it's okay. With time, with feedback of your educators, you will learn how to write a very good answer. Also you will get mentorship and guidance from your educators. So it's like a one-stop solution for complete UPSC CSE preparation. There are structured batches with top educators, batches in Hindi, English and bilingual. Okay, so there are also night batches as well as 2 years batch. Okay, so your 100% syllabus will be covered. There are vast range of optionals, prelims, test series with evaluation, mains test series with evaluation, dedicated doubt clearing classes, daily current affairs practice, essay and answer writing practice, performance analysis, sectional quizzes, interview preparation, etc. All of this you will get with one subscription. So here is the detail of 4 new batches that are going to start soon on Unacademy. So first one is Mission UPSC CSE 2021. It's a bilingual GS batch course starting from 31st of August 2020. It's a full year batch course. It's like full syllabus coverage will be given with top educators. Prelims and mains test series with analysis will be given, and PDF study material, dedicated doubt clearing sessions, interview preparations, etc. This is a bilingual batch. Okay, so you will be taught in both the languages, Hindi as well as English. Next one is Lakshya UPSC CSE 2021. So it is going to start from 31st of August 2020. So this is for the people who are preparing with Hindi medium. Okay, it's also a 1-year batch. Your whole syllabus will be covered. Okay, prelims and mains test series will be given to you. And next one is Expedition UPSC CSE 2021. So you will get it is starting on 31st of August. So this is for the people who are preparing with English language. Okay, so your entire classes will be in English language. Also, all of the study material that you will be getting will be in English language only. Same you will get, it's a 1 year batch course, full syllabus coverage with top educators, prelims and mains test series with analysis, PDF study material, dedicated doubt clearing sessions, and interview preparations. Next one is Mission UPSC CSE 2022. So this is for the people who are preparing for their UPSC exam in 2022. So it's a bilingual GS batch course. It's a 2 years batch course with full syllabus coverage, top educators, prelims and mains test series with analysis, PDF study material, dedicated doubt clearing sessions, and interview preparations. Also, you can use our code SIMPLEYT in order to get an extra 10% discount. Okay, so this is how it works. So if you click on this get subscription button, then like this page will appear. So suppose if you are subscribing for 24 months, then you have to pay rupees 64,000. But when you apply our code SIMPLEYT, it will reduce to 57,600. So approximately there is a discount of around 2,000 or 2,500. Okay, but आपको ये डिस्काउंट तभी मिलेगा जब आप हमारा कोड यूज़ करेंगे, विच इज़ SIMPLEYT. Do not forget this code. Also, I'll be mentioning one contact number. So if you have any difficulty regarding this code, regarding applying this code in your this subscription time, so you can contact us on that number. Also, there is this T20 daily current affairs test series, which is for free. It daily actually happens at 7:30 p.m. There are like 20 questions for 20 minutes and it's of 40 marks. Okay, so I guess you can spare 20 minutes daily to update your current affairs. It's totally based on current affairs and you won't be charged anything for it, and you will be given a test analysis as well by the end of every test. You can also join Unacademy's YouTube channel, that is Unacademy Articulate, Unacademy UPSC Current Affairs, or Unacademy Lakshya UPSC CSC, UPSC CSC Mock Interview, The Last Mile. You can also follow Unacademy on Facebook, and you can also join their Telegram group, which is Unacademy Articulate. Also, you can join our Telegram group, which is Simple Concepts UPSC. So the benefit of joining our Telegram group is that you get all of the PPTs which I'm teaching. ठीक है, ये जितने भी PPTs हैं मेरे lecture की, सब आपको इस group पे मिल जाएंगी. Also, we provide notes and current affairs capsules and quizzes and different kind of study material on our group. So you can join our group. वैसे मैंने इसका जो link है वो description में mention कर दिया है. But still, if you don't find that link, so what you can do is open your Telegram app and then type Simple Concepts UPSC, and then you will get this group. Also, you can contact or WhatsApp us on this number 9689638048 if you have any query regarding like what to study and how to apply our code in order to get discount. What else do you need to know about Unacademy or UPSC? Like any query regarding UPSC, you can contact us. Either you can call us or you can WhatsApp us on 9689638048. So by this, let us begin with the lecture. So okay, these are the important judgments. So I'll just read out the names, and then I'll in brief tell you what is each and every case is about, and brief description about it. We will not go into a lot of details. I'll just tell you why it is important. So first one is Ramesh Thapar was a state of Madras. Next is KM Nanavati was a state of Maharashtra. Birubari Union versus unknown. ADM Jabalpur versus Shivkant Shukla. Menka Gandhi versus Union of India. Minreva Mills Limited versus Union of India. MC Mehta versus Union of India. Indra Sahani and others versus Union of India. Muhammad Ahmad Khan versus Shah Banu Begum and others. SR Bomai versus Union of India. Lilly Thomas versus Union of India. Justice KS Puttaswamy retired and another versus Union of India. And Nalsa, I'm sorry, A is missing. It is NALSA. Okay, Nalsa versus Union of India. So I have not mentioned about the years. You just need to know कि what these cases are about. Some of them are very old, some of them are very new, okay, but बहुत सारे landmark judgments हैं ये, okay, like a lot of difference has been created by these judgments in our judiciary or executive or our law system, okay. So let us discuss one by one what is each and every case is about. So the first one is Ramesh Thapar versus State of Madras. So Ramesh Thapar case upheld the freedom of speech. It is about freedom of speech. So this Ramesh Thapar, there was this एक न्यूज़पेपर एजेंसी आप कह लीजिए वो थी, okay, it was held that liberty of the press is an essential part of the right to freedom of speech and expression. Okay, the judgment was quoted again and again by Supreme Court, including in Shriya Singhal case, in which it set aside Section 66A of the Information Technology Act. So इस केस में ये बोला गया था कि although हमारा जो फ्रीडम ऑफ स्पीच है उसमें फ्रीडम ऑफ प्रेस एक्सप्रेसली कहीं पे भी मेंशन नहीं है, स्टिल फ्रीडम ऑफ प्रेस कम्स अंडर आर्टिकल 19 ऑफ इंडियन कॉन्स्टिट्यूशन. हमारे फ्रीडम ऑफ स्पीच में फ्रीडम ऑफ प्रेस भी इंक्लूड किया गया था आफ्टर दिस केस. सो दिस रमेश थापर वाज द हेड ऑफ अ प्रिंटिंग प्रेस, ओके. सो वो स्टेट ऑफ मद्रास में एक न्यूज़पेपर पहुंचाते थे, बेसिकली उनका एक प्रिंटिंग प्रेस था. सो ही रोट समथिंग अबाउट द गवर्नमेंट एंड गवर्नमेंट बैंड दिस newspaper in Madras. So this question was raised before the Supreme Court, and Supreme Court held that the freedom of press is like part of Article 19. Like हमारे freedom of speech का integral part है freedom of this press. Okay. So this is about Ramesh Thapar versus State of Madras. Don't worry, I'll cover this all, like each and every case in separate videos. Next one is KM Nanavati versus State of Maharashtra. I hope you all have seen that movie Rustam. So this is somewhat like that case only. KM Nanavati planned a murder. Okay, he was a Navy official, and why this case is important, because this was the last case in India जिसमें जुडिशरी के जुडिशरी बोल रही हूँ जूरी के डिसीजन को माना गया था. उसके बाद से जो जूरी सिस्टम है इंडिया में उसको बिल्कुल ख़त्म कर दिया गया था. दिस वाज द लास्ट केस जिसमें जूरी के डिसीजन को बेसिकली माना गया था. Next is Berubari Union versus Unknown. So I have already discussed this in my first video of polity lecture, that is Union and its territories. So Berubari Union was actually a part of Bengal. ठीक है, फिर उसको इंडिया से अलग करने की बात आई. Like the parliament decided to secede this part to Pakistan. सो उसके ऊपर काफ़ी सारे इश्यूज रेज हुए कि उसके ऊपर आप उसको एग्जीक्यूटिव एक्शन से किसी और कंट्री को दे सकते हो कि नहीं. आर्टिकल 2 के अंडर या आर्टिकल 3 के अंडर क्या ये पार्लियामेंट का राइट है, या फिर पार्लियामेंट के पास ये पावर्स आ जाती हैं कि वो किसी भी टेरिटरी ऑफ इंडिया को किसी कंट्री को दे सकता है विद जस्ट एन एग्जीक्यूटिव एक्शन, या फिर उसके लिए कोई कॉन्स्टिट्यूशनल अमेंडमेंट चाहिए. इन सब का आंसर बेरूबारी यूनियन वर्सेस अननोन में दिया गया था. Next one is ADM Jabalpur versus Shivkant Shukla. So in this case, ADM Jabalpur case actually deals with the power of High Court to issue a writ of habeas corpus. In my previous video, I have also explained about what this writ means. ये writ कब use आती है? So generally, legal experts consider ADM Jabalpur judgment as an unpopular judgment, but it still continues as a good law. There has been considerable judicial introspection and admission by former judges that ADM Jabalpur was wrongly decided. So what happened was that in general election of 1971, Srimati Indira Gandhi contested and won from Raebareli constituency. The election of Indira Gandhi was challenged by Raj Narayan, a defeated candidate. Okay. On June 1975, Justice Jagmohan Lal Sinha delivered the verdict in state of Uttar Pradesh versus Raj Narayan, जो कि राज नारायण ने केस डाला था इंदिरा गांधी के अगेंस्ट. The Allahabad High Court convicted Indira Gandhi of having indulged in electoral wrong practices and declared her election void. मतलब उन्होंने बोला कि जज ने बोला कि जो इंदिरा गांधी ने जो इलेक्शन जीते हैं वो void हैं. She was barred from contesting any elections or holding office for a period of next 6 years. On her appeal to the Supreme Court, it granted her only a conditional stay. ठीक है, उन्होंने सुप्रीम कोर्ट में जाके अप्लाई किया, जिसकी वजह से सुप्रीम कोर्ट ने उनको सिर्फ एक कंडीशनल स्टे दिया. Her powers in the matter of vote and speech in the Lok Sabha was restrained. उनके जितने भी पावर्स थे लोकसभा में वोट करने के लिए, सुप्रीम कोर्ट ने बोला ये पावर्स हम आपसे ले लेंगे. In desperation to hold on to power, Srimati Indira Gandhi requested the President Fakhruddin Ali Ahmed to declare an emergency under Article 352, Clause 1 of Indian Constitution. The ground for imposing the emergency was that a grave emergency existed. तो इंदिरा गांधी ने तब प्रेसिडेंट को बोला कि आप इमरजेंसी लगा दो. So there were like a lot of people arrested during that emergency. जिसने भी आवाज उठाई इस इमरजेंसी के खिलाफ उनको अरेस्ट कर लिया गया. The arrested people filed a petition in various high courts for the same issue of a writ of habeas corpus and challenged their detention. Most of the high courts ruled in favor of the arrested people. High courts broadly took the view that despite the presidential order, it is open to the detentors to challenge their detention on the grounds that is ultra virus. I hope you have understood what was the background of it. It's a very long case, so I'll explain it in a different video. Okay, so this is all about basically habeas corpus की जो power है वो हाई कोर्ट के पास भी है, ये इस केस में बोला गया था. So next one is Menka Gandhi versus Union of India. So what happened in this case was that this case established the relationship between Article 14 and Article 19. It expanded the scope of Article 21 of the Constitution. So the background is that Menka Gandhi was going abroad and due to some reason, ठीक है, गवर्नमेंट ऑफिशियल्स ने उनका जो पासपोर्ट था वो जब्त कर लिया था. उस वजह से मेनका गांधी ने एक पिटीशन डाली ये बोलते हुए कि शी हैज़ अ राइट टू फ्रीडम, लाइक शी कैन मूव एनी वेयर शी वॉन्ट, नोबडी कैन एक्चुअली डिटेन हर पासपोर्ट विदाउट एनी वैलिड रीजन. सो इस वजह से क्या हुआ, इससे पहले, इस केस से पहले देयर वाज नो रिलेशन बिटवीन आर्टिकल 14 एंड 19. सो आफ्टर दिस केस अ रीजन वाज गिवन. कोर्ट सेड दैट आर्टिकल 19 के अंडर आप जो भी एक्शन लेंगे, गवर्नमेंट से ये बोला गया आर्टिकल 19 के अंडर आप जो भी एक्शन लेंगे, यू नीड टू हैव अ रीजनेबल रिस्ट्रिक्शन, or you can say you have to tell us about the reasonable restriction that you have put and why do you have put this certain restriction upon this law. कि आप अगर कोई किसी भी रीजन से अगर आपने मेनका गांधी से जो उनका पासपोर्ट है वो जब्त किया है, यू हैव टू वैलिडेट अस, या आपको हमें बताना पड़ेगा कि व्हाट इज द रीजन बिहाइंड इट, एंड दैट रीजन शुड बी अ रीजनेबल रिस्ट्रिक्शन. ठीक है, दिस रीजनेबल रिस्ट्रिक्शन इज गिवन इन आर्टिकल 14 एंड द स्कोप ऑफ आर्टिकल 21 वाज वाइडेंड बाय दिस पर्टिकुलर जजमेंट. So there is also one more judgment, Golaknath, which is previous to this Menka Gandhi versus Union of India. That is not important. This one is important. That Article 21 का जो scope है उसको बहुत wide कर दिया गया था. ये बोला था कि जो भी rights हमारे बाकी किसी भी आर्टिकल में नहीं पढ़ रहे हैं, they will be considered as right under Article 21. What is Article 21? Right to life. Next one is Minreva Mills Limited versus Union of India. So what happened under this particular case, Minreva Mills Limited versus Union of India? कोर्ट ने ये कहा that there is a harmony and balance between fundamental rights and directive principles is an essential feature of the basic structure of the Constitution. It restored the power of court to review any amendment to the Constitution. So इस केस के अंडर एक तो कोर्ट्स को ये पावर मिल गई कि जो अमेंडमेंट्स हैं उनका भी रिव्यू किया जा सकता है, वो भी जुडिशियल रिव्यू के अंडर आते हैं. दूसरी चीज कोर्ट ने इस केस के अंडर ये बोली कि देयर इज अ हार्मनी बिटवीन फंडामेंटल राइट्स एंड directive principles of state policy, and this is the basic structure of Indian Constitution. Next case is MC Mehta versus Union of India. So this case actually changed the environmental law in India. This is a very landmark case. If you have heard of Bhopal gas tragedy, okay. So इस केस में क्या हुआ था, as you all know कि भोपाल में एक गैस लीक हो गई थी जिसकी वजह से बहुत ज़्यादा लोग मरे और अभी तक भी उसका इफेक्ट है. सो देयर वाज अ कॉन्सेप्ट ऑफ यू कैन से वी हैव अ लॉ torts. Okay, so a new concept was developed after this case which was known as strict liability. So strict liability में क्या होता है कि even if you are cautious, ठीक है, कि आपने पूरी सावधानी बरती थी, आप ठीक है एक इंडस्ट्री खड़ी कर रहे हो, आपने पूरी सावधानी बरती, you took all the precautions, everything, but still this happened, like a disaster happened. तो पहले क्या होता था, if you are not negligent, ठीक है, पहले strict liability के concept से पहले if you are not negligent and still some disaster happens, then it is not your fault. ठीक है, it is force majeure, मतलब ये भगवान की इच्छा से हुआ है. But after this case it was held that even if you were cautious enough, आपने कितने भी precautions लेते, but you yourself brought a disaster upon this land. आपने अगर ये factory लगाई है and you knew कि this gas is harmful for people and if it gets leaked तो क्या होगा, लोग मरेंगे ही, then it is your fault and you have to pay. एंड पे वॉट, आपको तब तक पे करना है जब तक उस एरिया में सिचुएशंस वैसी ही नहीं हो जाती जैसी उस गैस के लीक होने से पहले थी. तो इसके बाद पहली बार किसी कंपनी ने इतना बड़ा कंपनसेशन पे किया था आफ्टर दिस स्ट्रिक्ट लायबिलिटी वाज अप्लाइड इन एनवायरमेंटल लॉ, कि अभी तक भी वो कंपनी जो है वो पैसे दे ही रही है, लोगों को कंपनसेशन पे कर ही रही है. वो कंपनी खुद भी बंद हो गई लेकिन स्टिल इट इज पेइंग कंपनसेशन टू पीपल बिकॉज द सिचुएशंस देयर हैज नॉट रिस्टोर्ड टू द ओरिजिनल वन. क्योंकि अभी भी वहाँ पे जो लोग पैदा होते हैं दे हैव सर्टेन डिफॉर्मिटीज, फिजिकल, मेंटल, सो तब तक वो कंपनी पे करती रहेगी जब तक उस जगह पे सिचुएशंस वैसी नहीं हो जाती जैसी उस गैस के लीक होने से पहले थी. सो दिस इज अबाउट द स्ट्रिक्ट लायबिलिटी. Next one is Indra Sahani and others versus Union of India. So I'll tell you in brief. Indra Sahani case upheld the constitutional validity of the office memorandum that provided 27% reservation to the backward classes. It held that reservation should not exceed 50% and the reservation in promotion is constitutionally impermissible. सो इसमें ये बोला गया कि जो टोटल रिजर्वेशन है इट शुड नॉट एक्सीड मोर दैन 50% एंड जो रिजर्वेशन है प्रमोशन में इट इज कॉन्स्टिट्यूशनली अनपरमिसिबल के जो आपके प्रमोशन में जो आपको ये मिलता है रिजर्वेशन, दिस इज कॉन्स्टिट्यूशनली इम्परमिसिबल. सो ये दो चीज़ें इंदिरा साहनी वर्सेस यूनियन ऑफ इंडिया में बताई गई. Next one is Muhammad Ahmad Khan versus Shah Bano Begum and others. This case is also known as Shah Bano case. So after this, certain rights to the Muslim women were available to them. Okay, so if I give you a gist of this case, so the Talaq-e-Biddat was abolished after this case. मतलब ट्रिपल तलाक की जो डिसीजन था वो इस केस में दिया गया था. सो ट्रिपल तलाक वॉज एबॉलिश. सो आई मस्ट टेल यू देयर आर नॉट ओनली वन टाइप ऑफ divorce in Muslim law, Muslim personal law. There are many types of divorce. Okay, so one of them is talaq-e-biddat, which was declared unconstitutional. So it was held that जो uniform civil code है it applies to all of the Indians and it actually supersedes any personal law in India. Also, the constitutional validity of this particular kind of talaq was in violation with fundamental rights of Muslim women. So that's why it was declared illegal. Okay, so triple talaq was basically banned after this case. I'll make a separate video for this. This is a very important case. Next one is S.R. Bomai versus Union of India. So under S.R. Bomai case, it is related to the proclamation of emergency under Article 356 of the Constitution. The case also dealt with the power of the President to dissolve state legislative assemblies and the issue relating to federalism and secularism as a part of the basic structure. इसमें बोला गया कि secularism और जो फेडरलिज्म है दैट इज द बेसिक दैट कम्स अंडर द बेसिक स्ट्रक्चर ऑफ इंडियन कॉन्स्टिट्यूशन. इट पुट एन एंड टू द आर्बिट्ररी डिसमिसल ऑफ स्टेट गवर्नमेंट अंडर Article 356. So इसमें बोला गया there should be no arbitrary dismissal of state government. It was also held that proclamation under Article 356(1) is not immune from judicial review. So इसमें ये भी बोला गया कि जो आर्टिकल 356 क्लॉज 1 है वो जुडिशियल रिव्यू से इम्यून नहीं है. सो आई मस्ट टेल यू देयर आर फ्यू articles in Indian constitution which are immune from judicial review. So this particular article 356(1), the cause of emergency, is not immune from judicial review. Okay, the court can actually see whether the reason that is being given to apply emergency under article 356 is valid or not. Next one is Lilly Thomas versus Union of India. So in Lilly Thomas judgment, it was aimed at freeing the political setup from the criminal elements. इसमें बोला गया कि जिसके ऊपर भी criminal charges हैं, they should not be allowed to contest elections. So the Supreme Court held subsection 4 of Section 8 of the Representation of People's Act is ultra vires the Constitution. Next one is Justice K.S. Puttaswamy, retired, and another versus Union of India. So this is related to the very famous case. This is a very recent case. In this, it was held that right to privacy is a fundamental right. So if you know कि हमें मांगा गया था कि आधार कार्ड is mandatory in each and every document, ठीक है, चाहे वो आप इनकम टैक्स रिटर्न फाइल कर रहे हैं या फिर आप अपना बैंक अकाउंट में लिंक करा रहे हैं. सो इट वाज नेसेसरी कि अगर आपको कोई भी गवर्नमेंट स्कीम चाहिए, सो यू नीड टू एक्चुअली रजिस्टर योर आधार कार्ड in each and every scheme. So under this judgment, basically it was held that the question was arise whether we have right to privacy. इसमें बोला गया because we have right to privacy and because the आधार कार्ड में हमारे pupils के measures या फिर हमारे prints हैं, hand prints हैं. So this is our right. Anybody can use it. So do we have a right to privacy or not? So court said yes, right to privacy is a fundamental right under this judgment. Next one is Nalsa versus Union of India. So in Nalsa versus Union of India, some of the very basic right which is necessary for the development of a person was given to transgenders. Okay, so this case is related to transgenders, that they will be given equal opportunity in each and every government exam or job or everything. Like the transgender community basically got their basic rights in this case, which is Nalsa versus Union of India. I hope you have got the gist of each and every case in this. If you have any doubt, you can ask me in the comment section and I'll try to answer all your queries, and I'll make separate videos on each and every case so that you understand them in a very much depth, so that you can build your own views on each and every case. So I'll see you all in the next video. Till then, please take care and bye-bye.